thundering thud sounds that suddenly goes boop, 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 at one go.
Alright, welcome back to our So Far So Good Season 2. We are right now on episode number 5, and of course, I think today is a very exciting episode because we have a lawyer in the house, and we're going to talk about some sensitive matters relating to tenancy agreements. So for our guest today, Mr. Anil, he is from DL Law Corporation. He has been practicing law for the past 18 years, and we're very honored to have him in the house today, and he focuses a lot on employment law, business law, company law, contracts, draftings, mergers and acquisitions, and he has a passion with dealing with accounting and financial statements, as well as protecting business owners and SME, and he also has a wealth of experience when it comes to tenancy issues. So Anil, thank you for coming on So Far So Good.
Thank you.
Good to have you here on a Friday. I don't know whether my introduction was good enough. Maybe you can share a little bit with our audience casually about your experience in the years.
You hit it spot on when you said that my passion was actually to look after my businesses, because it seems like for SMEs, there isn't enough work, there isn't enough expertise that goes about where a person or a business owner is able to use that information to his benefit, because it's always costly to get very expensive lawyers. So the idea here has to be, as a business lawyer, we have to look in the shoes of the business owner, of the company. What exactly does it read? It needs, of course, all the basic information. It needs all the employment information. It needs to know whether it's got contracts ready. It needs to know how to deal with its landlord. Because if you're not able to deal with your landlord, then what you really have is a situation of a fallout that results in, what do I do? And look, let's be honest. All business owners at the end of the day are tenants. Right. And that's the truth of the matter.
Right.
Yeah.
Right. Maybe share with us a little bit about your weekly activities. What do you do on a day-to-day basis as a lawyer?
I carry out two areas of work very much. One is, of course, in litigation. In other words, what happens is you have clients who come to me telling me we've got a problem. They've either been sued or we need to sue. Okay? When I say sue here, what I'm really meaning is we need to recover monies, or we need to fight for a right, or to have a performance of a certain matter sorted out. So it involves the courts. So I am involved with the courts in these circumstances. What is typically known as a dispute resolution. Litigation is the long phrase for it to suggest that there's disputes and problems between the parties. The other part of my work is actually with regard to drafting with corporate matters. Of late, I've specialized a little bit more with sale and purchase of businesses, sale and purchase of companies, and therefore advice is needed for these circumstances. I also have some experience in dealing with shareholders and directors, which is the other dispute you get in company most of the time. Again, I deal with business owners. I deal with mainly SMEs. If you ask me my typical day, that actually starts as early as 7 in the morning.
Wow.
Because we'll have to deal with whatever that needs to be done.
Okay.
Right? Quite honestly, looking at documents, drafts. End work. Okay. Officially, to my wife's timing, I'm supposed to stop at 7.
Right.
But it doesn't happen that way because it goes on for circumstances. But let me be honest with you, it's not always this way, because somewhere between the 7 and 10 o'clock, I do take some time off for myself, whether it's to look after my own health, exercise, to think about certain circumstances. That is, I think, very necessary.
Right.
It is stressful. But it's necessary.
Okay. What gave you the passion to practice law when you just started out?
Will 45 minutes be enough for me?
Yeah.
Well, no, actually, I've always been passionate about law because I have this sense of justice that I think I need to deliver. And then your question to me is, why don't become a judge? No, that's a separate issue. This is about advancing someone's rights. It's about telling somebody that, hey, listen, you have a right, and let me just be that advocate for you to be able to push through. Things are changing in the legal fraternity because nowadays there's less of advocacy, meaning that I'm going to court and explaining. There's less of that. There's a lot more written advocacy, which means that I now have to be able to submit in written form my arguments so that the judge is persuaded by my arguments with facts, with legal authorities. That is the change. That is something that's probably a whole topic altogether. My passion comes about really because it involves people. It's about pushing forward someone's views. It's about making sure that you look after that particular person. And sometimes you may not have the benefit. You may not have the right facts. Sometimes you may not even have the right circumstances.
Right.
But you need to put forward a view. You have to.
Right.
The lease. Or we find the middle ground. We negotiate. We walk away. Because every litigation is an expensive cost. Time costs, management costs. Then you have to ask yourself, look, wasn't it better if I just settle this matter separately? because then it's not expensive because I should focus on my business, right? That's what I'm there for.
Right. And it's about finding a sweet spot
Entirely.
Right. Great. Okay, we have quite a lot of questions to cover, and
Sure.
we hope to be able to cover within the next 45 minutes. And
Sure.
Okay, let's dive in, and we want to talk about situations from both perspectives. That means as a landlord and also as a tenant.
Sure.
In fact, we have some very specific case studies as well, and I just want to see your opinion. So, for example, let's say if someone is a tenant and they've been renting this maybe this condominium apartment for the past 1 year. What if one day there is like a building shutdown? Maybe because it's an old apartment, and then there's been a power outage for 2 days that affects the entire building, and thus all the residents are affected. From the tenant's position, what can the tenant do? Can the tenant seek compensation for the landlord? Because it's coming from the MCST point of view. So
Yes.
yeah, just wanted to seek your advice on this.
Maybe I'll set the tone out for this correctly. We're looking at two different kinds of contracts. Huh? One is the residential contract, the one that you're talking about, and there's a commercial contract to it. That's one. The second aspect of it is a lot of contractual arrangements, or rather a lot of the relationship between the landlord and the tenant has to be contractually based. Okay? And key component of any agreement in a tenancy agreement is exclusive possession. What does that mean? It means that you, the landlord, after having given to me this or granting to me this right, doesn't interfere with how I deal with my property or the property that you have leased to me. Exclusive possession. Very critical phrase. Okay,
Right.
It's different from me going to a place and saying, "Oh, can I use this room? Right? I want to use it for a short while, or I'm going to be here only for a short," because that becomes a license, and that's the misunderstanding that some people have. Oh, because I used that place, therefore I became a tenant. Issue here at the moment is shutdown, which is an internal issue relating to the building as opposed to the premises. Okay. So if you ask me, hey, look, what rights do I have if the building got shut down for 2 days? It doesn't only affect one person, it affects everybody.
Right.
Right? But if you had changed your question a little bit and you had asked me, hey, I am unable to go into the premises because for some bizarre reason, this particular place now is completely inhabitable. I'm using a very legal phrase of here because there's a big definition for this word inhabitable. It means that I cannot live in this particular, and I'm not talking about, oh, because there were roaches or there were termites that it becomes, no. No, this is something in which I cannot live in the premises, probably because it blew up. Then you may have a relief. The relief would be what's known as a frustration. Frustration is a phrase, another legal phrase that says, look, I'm not able to perform this agreement because this incident occurred. The truth of the matter is insurance comes in, there's cover for this. Really, what are your rights in these circumstances? You go to the landlord and says, can you please reduce it? He'll say no, because the truth of the matter is contractually he hasn't given up exclusive possession. These are external circumstances that affected the premises,
Right.
including a shutdown of a building.
Right. So what if the tenant comes from a point of view that because of this shutdown, they are unable to function in the premise because there's no electricity, they can't work, there's no aircon, and they can't cook and things like that. So are they able to seek relief from a landlord, like maybe a reduction in rent and things like that?
So comes back to the frustration point again, right? Usually the period, there's in the contract, you typically have a certain number of days. And it's to allow people to actually solve the problems themselves. Okay? But if you couldn't, let's assume that you had a period of 30 days, not just 2 days, 30 days. Then the contract can cater for this, where you say that, look, if in the event I'm unable to deliver, I will be able to leave the particular premises or bring an end to the contract or suspend the contract. Those are frustrating events. Okay?
Right.
Frustrating to the tenant as well, but frustrating in the legal sense means that I'm able to get out of the contract for these. It wouldn't happen for 2 days typically. Okay, the other thing that very clever landlords do is that we include clauses in there that says that in the event something of this nature happens, we will suspend the contract and I won't collect rental from you, but it doesn't bring an end to the agreement. Because every landlord is worried that if I lose my tenant, what's going to happen? I'll have to go and find another tenant, have to find another agent to go and market the place. That's all difficult stuff.
So what's the easiest way to solve this? Like
Negotiate.
If you are the tenant.
Negotiate, right? Because the landlord is going to tell you it's not my fault. It really isn't, right?
Right.
But if it was due to a fact that the whole place was really inhabitable, using the exact legal phrase, then you may be able to go to the tenant and tell him, look, I've got to the landlord to say that, look, I've got reasons to believe that I'm unable to live here for much longer. And I'll give you one incident. There was a heater at the top of, a water heater at the top of the premises. Okay?
Was it a landed property or?
It was a landed property, and it was a fairly large one, and there were multiple heaters. Now, what happened was, for some bizarre reason, the biggest heater exploded. Okay, I think it was because it was not maintained properly, or it wasn't serviced, or something along those lines, and it just exploded. It exploded, and there was a waterfall right across, because it flooded almost every, and the tank is not small, it was a big one. And so it went through quite a bit of damage, it went through. So obviously the tenant, my client, came by and said, look, I want to walk out of this tenancy agreement, right? So we took a step back, asked ourselves, was this a frustrating event? Meaning that it was an event that, because of an external factor, right, a force majeure or anything of that, suggesting that there's an act of God, or that would result in me unable to utilize the place. And the answer was, no, it didn't fit that test. Okay, then we ask ourselves, inhabitable, can't be lived. Well, the truth of the matter was, it was all flooded. That's what it was. Didn't mean that it couldn't be rectified. It could. I just get somebody, mop up the water. It didn't become inhabitable. But of course, they were saying, there was tremendous smell, right? Again, I could rectify this. So it came very close to it becoming inhabitable, but it wasn't. So we couldn't really exit, but we could then write to the landlord to say, you need to rectify these circumstances because these things have happened. In many of the clauses in the tenancy agreement, you actually see these things. It says that the landlord will be liable for up to a certain circumstance, a certain amount, $250, probably for lights. If there's bigger damage, or rather, I've got it the reverse, the tenant is liable to a certain amount of $250 or even $300. And anything beyond that, because of a serious major breakdown, and it's not due to the tenant's negligence, then the landlord is liable for this. So in this case, was the water heater a situation of this nature? It fell in that.
Right.
So you see here, the situation is whether I use whatever the circumstance, right? Your electricity shut down because of the building, or I use a situation that was massive floods or storms.
Correct.
Those things would change your situation, going through down my checklist and saying, okay, can or cannot. And that's what I would do. In this situation, I think what's the best thing to do? Negotiate with the landlord to say, look, I can't use the premises. I'm afraid most landlords will come to you and tell you, sorry.
Okay, I think that's great advice. And the key word that I understand is whether is it habitable or inhabitable, right? Let's switch attention to, let's say, example, if somebody is a landlord.
Yep.
And I think this is a very common issue pertaining to payment of rent.
Yes.
Yeah. So I think in most tenancy agreements, the standard nature is that after a certain period of days, if the rent is not paid, what can be done by the landlord? But I think sometimes what a lot of landlords face on the ground is that in actual practice, it might be a little bit difficult to execute this portion. So for example, if a tenant fails to pay rent for the first 7 days after the due date, and for example, if the rental is due on the 1st of every month,
yes,
but until the 8th, there's no payment received. What's the first thing that the landlord should do?
Okay, again, right, we're looking straight down to the express terms and conditions of a very hard-fought battle tenancy agreement. You look at the tenancy agreement, clearly it says the landlord will be able to enter the premises.
Correct.
Charge
the
for
most common
interest.
term. Yes.
Usually it's there, it sits there so blaringly, and you ask yourself, oh my God, I'm a tenant, how am I going to get out of this? As the landlord, quite clearly, most landlords don't act after 7 days. Some do when they realize that the rental amount is very large, right? What do? You obviously have to take the first step. Nobody goes and says, I've got a lawyer next door, let me go and get the lawyer. Nobody does that, right? What they do is that they write their own letters to say, dear sir, we refer to the agreement. There's this rental that is due. You've not paid. Maybe you have overlooked one of those things that you've overlooked. Please make payment, okay? Please make payment within 2 days, 3 days, whatever it is, right? Nobody responds to the letter.
Yep.
Landlord gets upset. Hey, my rental, nobody's renting, nobody. Okay, the other thing also has happened is landlords now include the gyro clause. You know what's the gyro clause? Gyro clause is that I don't want to waste time with you. Please just go and put your money directly into my bank account.
Right.
So if the money doesn't go in, of course, you have a very frustrated landlord. He's going to say, look what's happening here. What's he going to do? Rightfully and legally, he has I can enter the premises if you have defaulted on payments. I can take over the premises. I can even lock the premises down as long as no unreasonable force is used. Another phrase, unreasonable force.
Right.
What does that mean? It means that I take over the premises suddenly and you'll be shocking everybody else because you haven't paid the rental, and it usually happens in this circumstance. But it's not common. Do you really want to determine or bring an end to a tenancy agreement who has been paying regularly except for 1 month because he missed it? But that attracts another thing for the landlord. It's in the contract that allows the landlord, most contracts, that there's an interest clause. There's an interest clause for me to charge you if you paid late. So, what would that landlord do if he was unable to recover the rental, not be able to hear from the tenant, not going to be sure that he's going to be paid the interest?
Yes.
What do? You still have the deposit, because guess what? Any tenancy agreement allows you to ensure that you retain 1, 2, 3 months of tenancy. But then you're going to tell me, but what's the tenancy agreement for? What's the security deposit for? The security deposit really is to go and reinstate your place. It's to protect against faults in the building, because we don't know what you've done in the building.
Yep.
And therefore, so usually you don't use your security deposit. But when you know you have the security deposit, would you immediately go and get a lawyer and say, hey, send a letter 7 days missing? You would only do so when you have a tenant who has not been paying attention, a tenant who has been defaulting regularly, because you don't know what's going to happen. And usually these tenants are the ones who allow rental to be defaulted by at least 2 months, almost equal to the security deposit. And that's when you have to be really careful. You do not wait. You send the letter immediately. You tell them. Now, who sends the letter? Should I send a landlord to send the letter? It's okay. Make sure when you send a letter in, you indicate exactly what are you referring to. If you're referring to the fact that payment has not been made, you're not suggesting that there's a breach of the contract. You're only suggesting that this amount is due and payable. 2 things, due and payable, landlord?
Yep.
Or are you saying you want to bring an end to the agreement?
Yeah.
2 different things. So if I just want to make a complaint and say, look, you haven't made my payment, please make my payment. Ultimately, by not making payment, I can say you have breached the contract. But there's no point of getting this very technical about it. In your letter, keep it very simple. Ask for the money that is due to you and wait for it.
Right.
If they don't respond, then I'm afraid you have to activate the next circumstance. Many times, like now, when we have a COVID situation, what do? Some tenants say, I really have no money. Really. Do whatever you want to do. What do? There was a framework that was prepared for by Ministry of Law. Of course, that is the COVID Temporary Measures Act that allowed landlords and tenants to negotiate, provided certain conditions were met, and of course, certain circumstances to get out. This is now have come to an end of it. The temporary measures only apply to certain circumstances, but fundamentally, we are still stuck in the same problem. I have a long lease, 2 years. I can't pay you. Most landlords have gone, I'll give you some time to survive, because you may not find the next tenant, right? But legally, what does the landlord have a chance to do? Easily. He can go in, he can take possession of the premises, he can give notice, and he can determine the lease and say, okay, you're in breach of your contract because you have failed to pay, get out. In short. What does the tenant do?
Okay, maybe before we go to the tenant
Yes.
let's just backtrack 1 step. So 7 days, letter written, and then the next step is after 14 days, nothing happens. And then the landlord doesn't hear from the tenant. And let's say just for example, this is a small apartment. Rental is only like 3,000. Deposit is 1 month because it's a 1-year lease, which is very common. Although the deposit is sort of like a protection, right? But it's eating into the deposit already. And let's say until the 21st day, there's still no response. What should the landlord do?
I think it's critical that he has to engage lawyers to send letters, because you want to protect your position that there's a breach.
Right.
Okay. Many times, right, landlord make the mistake of not writing the correct letter, or writing a letter that doesn't ask for what they're asking for. Okay,
By which day do you suggest that, let's say it's in this very particular situation, it's a one-year lease, there's only a $3,000 deposit, 7 days no news, 14 days no news, and then what should the landlord do?
By the 21st day, close to the end of the month, that means a month has gone by,
Yes.
you have to act on it or activate the tenant, because no landlord is going to just sit there without realizing why you have not made my payment. Most people try and make the payment within the 7 days because it's a sort of a free zone for me.
Okay.
But if it excludes the 7 days and then it goes on,
Right.
I think that's when you have to start asking yourself, look,
You have to take action.
interest first.
Right.
Yeah. Interest calculation is not easy, by the way, because you have to ask yourself how much is outstanding. $3,000, your example. So I have to calculate what is my interest computation. Oh, it is using divided by 365 days, the number of days you didn't pay. So if it was 21 days in your circumstance, I have to now take minus the 7 days, 14 days divided by 365 days, multiplied by the interest, 5%. It's not easy calculation,
Right.
but it needs to be done.
Okay.
Most people do what? I'm not going to calculate, make my payment straight away. Most landlords I'm talking about
Right.
have got this. The stricter landlords will have an accountant at the back already sending you a statement of account telling you have not made your payment. That would have happened, forget, after 21 days. After 7 or 8 days, on the 8th day, you will receive a letter.
Can they just take possession immediately? Let's say on the 21st day, can they just enter the premise? And what if, like, for the full 21 days, there's really the
Nothing.
tenant just MIA and there's no response?
Actually, the short answer is yes, they can, because contractually that's what it says.
Right. So they can enter the premise.
They can enter the premise as long as there's someone there. They can take over the premises as long as no one is there. In other words, there
They
shouldn't
can
be
enter
someone.
as long as there's someone there.
Yes, because I won't be able to get into the documents. When I won't be able to get into the premises, right? I get into the premises, I have to get through. The only way for me to lock it out is to take a lock and lock it up. As long as there's no unreasonable force use, I can effectively take possession in that way,
Okay.
right? At the same time, you also keep all the items, right, that are there. I've locked the item, I've locked the place.
Right.
So that's quite draconian. That's really what is in the tenancy agreement.
Sure. Okay, there's still some very rare cases. For example, after 21 days, the landlord goes up, knock, knock, nobody's there, call the tenant, nobody's respond. Tenant just MIA for whatever reason. They enter the premise, all the belongings of the tenants are there, but nobody is living there. Can they lock up?
They can seize the items because you send a notice to say that all of these items at the moment will be
Even though there's no response?
no response.
Okay, so then the next sensitive thing is, when can the landlord then remarket the property to find a new tenant? Like, how long do they need to wait out for the tenant to respond? Because the tenant really MIA.
Yes. So what do you do with the equipment and the items that are inside there? Laptops, clothes, stuff and everything else.
Yes.
Some landlords have just wrapped everything and put them together. Is it legal? Of course it is, not their item. Some of them have held on to it because they want to sell it off and recover their rental. Most people don't deal because it's got very limited value. If you're talking about residential, commercial, you may have a different value. There may be very expensive equipment in the circumstance.
Okay.
It's not commercially practical to take that kind of draconian step because at the end of the day, I still have to go through the process of whether I've done it legally. Now, if the tenant feels that they've been wrongfully, because the defense that they have is, I wasn't informed, you didn't give me notice. It would be a valid defense, for the tenant. For the landlord, it's very important notice. I think I mentioned notice in every segment that I've said here because that is a requirement in the tenancy agreement. It's a requirement.
So reasonable notice as in SMS, WhatsApp, text,
Yes.
letters to the premise.
Yes.
Yeah, but if the tenant just don't respond, then it's not the fault of the landlord.
No.
Right.
Yes. Notification is one critical component that has to ensure that the landlord has discharged its duty, that it is informed. Because if you have not informed, I can do the same thing without notice. I go in and say, this is all mine. Then I have a defense.
Right.
I will come forward to say, you never notified me. I know I'm late, but you didn't tell me. And I've seen circumstances in which we've actually set aside cases. Right?
Right. Share with us, what is one of the worst rental dispute you have ever seen, like or settled, pertaining to residential?
Okay, I have seen commercial. Residential, the worst ones are, recently actually I was involved in one. It's the situation in which you mentioned.
Right.
The party didn't understand what it meant by the contract, that it said that I could walk in and get my possession of the place. Because it's a foreigner, and foreigners have different understanding. Like if you were in UK, there's certain landlord and tenant protection for tenants. I can't just come and take your circumstances. I need to get certain rights to take you out. Okay? Now, having said that, right, there are procedures in court, our court procedures, in which what I call a writ of possession, of taking over certain circumstances. It is followed if I've met certain requirements in the situation. So if you ask me whether we can do it formally, yes, we can. Formally, I must go to court, apply to it. It takes some time. But if I go there and I take possession because what the contractual agreement says, that is also possible. So the difficulty here was the person didn't understand what it meant, and the landlord didn't want to engage lawyers. So the landlord, what they did was, they went in, the person was in a towel.
And you were representing the tenant?
Well, I was not representing the tenant or the landlord in this circumstance because of the facts, and I'm going to tell you now, right?
Right. It's okay. You don't have to review anything.
It was information that information that had come by and we had to decide whether we wanted to. It didn't make any sense.
To take the case, right?
Yeah. So effectively, the landlord went to the premises and there was a family member in there, and he was in a towel.
And the landlord just opened it?
The door was open.
Oh, okay.
So he said, you have to pack and go. So the poor family member is going, oh, let me call my parents and all that stuff. So the difficulty was, this chap was in a towel, right. And he's now asked, okay, you come out first. That discussion, you come out first.
Okay.
And in that, I think it was all in conversation in Mandarin, but effectively, the boy comes out, the landlord goes in, closes the door, and he locks the door. And he says, okay, now I'm going to wait for whoever's going to make my payment to me.
Okay.
It's 1 month, it's not like a big deal.
Right.
Now, if I am the concerned tenant, right, you didn't give me notice. This is wrong.
You just barged into my home.
You barged into my home. You didn't tell me. You didn't give me notice. You didn't serve notice. You didn't give me an opportunity to settle this particular matter.
Right.
Now, let's flip this. I'm the landlord.
Yeah.
For so many days. And landlords, right, when it comes to residential matters, I'm not going to serve you some notice. I'm going to give you WhatsApp communication.
Correct.
You haven't given me
the
paid, rental.
Yeah.
You have not paid your rental. When are you going to make payment? All of these emails, and it's worse if it's in WeChat, right? All be in Mandarin, right?
Yes.
Right? I haven't received my... So, is this notice, right?
Is that
this
considered
formal
notice?
Well, to some extent, it's not formal notice because it says you must serve the notice to me according to the tenancy agreement. So, I would argue that you have been notified, but it's
But
not...
serving notice nowadays, can it be electronic or it has to be
Yes, it can.
physical?
Of course, it can.
But it has to be formally written.
Formally, you're making the demand to say that you haven't done so, right?
So it cannot be a casual message.
Because that is just asking me. I'm not sure whether you're asking me...
Oh, okay. So you need to specify, I'm serving you a notice right now.
Correct,
Okay.
yes. That serves the requirements of the contract per se, because that's how any notice needs to be served, has to be done formally, right? But think about this perspective. I mean, really caught. I have a person, family member, probably doesn't know about tenancies and contracts and everything else.
Yep.
He's in a towel, he's asked to get out of the house,
Right.
which he complies with the landlord, and now he's stuck. Because what does he do? He can't go back in. The door is locked, and he says, look, let your parents come in and settle. Of course, the matter is negotiated. They settle between themselves. Eventually, they're asked to leave.
Right.
I'm not sure whether they continued because it wasn't something we wanted to pursue.
Right.
It becomes very difficult. And one platform for this, which could be very relevant, right? And I say this similar to something like an employment tribunal between an employer and employee, right? There is some talk at the moment about having a same mediation platform for landlords and tenants. Because there are many disputes that go on between the parties, especially in these circumstances, and it may be too expensive to get a lawyer involved.
Right.
Because you need to write letters, you need to read through contracts, and then the lawyer says, look, my cost is going to be quite expensive. And then you said, look, what is the claim for? Oh, it's for 1 month's rental, $2,000. Oh, please. It doesn't make any sense. Do you see? So these mediation circumstances, the small claim tribunal has got jurisdiction to hear matters of this nature, up to a sum of $20,000. And also you have a period of up to 2 years for a residential contract. Right? So beyond that, it's outside the scope. So there is scope and mechanism for parties to go and dispute this or resolve this without using lawyers.
I see.
That's why most of the battles are in commercial matters.
I see.
Rather than...
Is it troublesome to go to a small claims tribunal? Like how long is the wait?
Nowadays, it's not very difficult because you can make an online application. It's quite straightforward. And the application, as long as it's within your jurisdiction and you are a person who is renting out an individual, you are able to make that. And it's not expensive, it's cost effective.
Right.
Sometimes, to be honest with you, I've actually advised many clients
to go
do
to small claims.
Listen, you want to talk to me, come and talk to me for some other matters, I'll help you. But for this particular matter, please go to small claims yourself. It'll be easier, you'll have mediation, the process is there. The courts have thought about it, the system has thought about it,
right,
to allow you to resolve your matters. And really, there are matters between how much rental are you going to be paying? $1,500? $2,000? $2,500? $3,000?
Right.
$5,000? Still, if you think about the grand scheme of things,
right,
things that can be resolved. And this is where, when you talk about tenancy, there's also this room, I've rented a room out.
Right.
Are you a tenant or are you just basically a licensee? Are you here to just use the room or a subtenant? Any circumstance that involves a subtenancy, that means if I have to ask somebody, I am the tenant and I want to give it to somebody else, requires the consent of the landlord. It's in any given written contract.
Yeah, the subletting portion.
It is one in which some are so stringent, it says you can't. Or in certain circumstances, it says you can, provided you have my consent.
Right.
Of course, the less relaxed ones are, I allow you to consent, but only so many number of people. Rare, happens more in commercial tenancies rather than residential.
Thanks. I think you point out so much good points about that particular question. So just off my head, what if also from a landlord's perspective, the third situation is that if let's say you're a landlord and then your tenancy has just ended and then the tenant somehow refuse to leave the premise because of certain reasons, like maybe the tenant says that, oh, I still cannot find a place. What should the landlord do? I mean, if after exhausting a reasonable amount of discussion, like, okay, would you want to extend the rental and things like that, but the tenant somehow is in a very unreasonable phase and says that, no, I just want to stay for another 10 days or 14 days. What should the landlord do? And because the agreement has ended, can they just go in and take over? Or should they appoint a lawyer? Should they? What are some of the best practices?
Let me frame this question a little differently.
Sure.
Let me put this in the scenario that you have put in. It is 31st of October lease ending. Okay?
Right.
2 months before, I've already got my agent going in and looking at the premises.
Correct.
Tenant has already been given notice. Tenant himself has said that 31st, I'm coming to the end of the lease and he's supposed to leave. Okay? 2 things come out from there. One is whether there's reinstatement works. In other words, I have to bring the place back to what it was when I took the premises. And the other thing is whether there's any minor works or rectification that I must do. Reinstatement or rectification. These 2 tend to be the base. Okay. The landlord is now come. He said, okay, let's do a handover. Who would the handover involve? Agents, because sometimes landlords are very busy and they send their agents in, and the agents will say, okay, now let's go through the list. Are the switches there? Are the fans there? Is the aircon there? Is everything? Okay, good. I've got all of the list of things now. Your scenario to me is tenant, right? And I don't know why he would do this. He says, okay, now I don't want to go because I don't have a place to go. Okay. Again, right? Contractually, right? You have no basis to say you don't want to go. No basis. But if you decide what's known as hold over the premises after that particular deadline, under the Civil Law Act, right, it actually allows the landlord to charge double rental. This was put in place actually to deter people from doing this.
Even if it's not in the tenancy agreement?
Yes, it's not. This is a statutory right.
Right. So it's like by default?
It's, okay, when you use the word by default, I'll say it's by law, by statute that says that I can ask for this money. I can come to you and say, look, now please give me a
double
rental. Okay? So as long as you're holding on to double rental, right, this situation can occur. Okay? Now, possession in a way would actually not apply, right? Because the tenancy has already come to an end. So can I apply on the contract? Because there's no breach per se. So what happens here? In a way, I think one solution, right, would be to, if you make this very difficult, apply for this writ of possession to take over. This is where the writ of possession will come about. Again,
How long does it take?
Takes time. It takes time. I have to apply to court.
And through a lawyer?
Through a lawyer. I've used the
21
court
days?
process. More than that.
And the tenant is still there?
The tenant is still there. But I'll have to ask for double rental.
Okay.
But most landlords, right, again would say, mafan.
Yes.
I really want to get this out of the way.
I want to quickly remarket my property.
Because if not, I'm going to lose. Unfortunately, that would be the mechanism. The other alternative is if the tenant doesn't leave in such a situation, most landlords will go and say, look, I want to file a police report. Most police people are very busy, okay? So they'll tell you, look, it's a civil matter, you'll settle between yourselves.
Right.
So what can I do other than, with a legal notice, claiming for that double rental? You're not even sure whether he's going to pay.
And how are you going to enforce it if the tenant just suddenly leaves one day?
Yes, and it becomes difficult if the tenant is a foreigner because his address is only tied to because you gave him an address.
Right.
And if you didn't give him an address,
and he leaves the country after that.
I'm afraid that's going to be the risk that you mitigate. So that's why I think sometimes in circumstances when landlords have this particular right, it's a lot easier just to make sure that they are negotiating this out of the way. And if really they need to extend it for a few days, out of goodwill, I think it's easier to extend because then you don't have this hassle of fighting and making sure. There is no clear mechanism to clear the person out except for this double rental that I'm entitled to ask
and the
for.
writ.
And the writ. And going through and seeing the lawyer. And of course, if you go and see a lawyer that is going to tell you the minimum cost is X amount of dollars that you're going to put down, then you're going to ask yourself, wait, $5,000 is what I'm asking for. Lawyer's fee $7,000, and you stop and ask yourself, wait, doesn't make sense, right? I'm missing something here. Because whether you do or not, I'm going to ask you for $7,000 irrespective.
Yeah.
Right? I'm going to do my job. I'm going to look at the contract. I'm going to tell you your rights.
Right.
I'm going to see everything. don't blame the lawyer. I'm afraid the only aspect of it is going to be this little problem over here. Now, can you make that claim against the tenant by making a claim to say he has not done so, not left in time? One circumstance that any lawyer advising would say that let's consider that the handover has not occurred. Let's indicate that the handover has extended. So that means there was supposed to be a handover date. It is not handed over, and therefore this is the extension. Most people will come and say, I'm taking the premise over, I'm locking the premises. Do you understand?
Yeah.
To extend the lease by saying that by virtue of the fact that there's no handover, you've not handed over the premises to me, you deem to be still in use of the premises, you still lease the premises, I'm going to continue double rental to you, and now going to exercise my clause to take over. That's the little bit of a circumstance that I can raise.
Right.
Each circumstance is different.
Definitely.
Right? If he has already crossed over, there's a handover, then he says he doesn't want to leave. It's different from him saying, I want to come over, and I do not say anything about handover. I just keep quiet.
Okay.
Then, of course, you're going to extend.
Right. So Anil, now comes a difficult question. So, what if after 2 months, the tenant still refuses to leave? And like you mentioned just now, the writ of summons takes time. Okay, usually how long does the application time take to apply for a writ of summons?
Two parts to this. One is, of course, how busy the lawyer is doing the work.
Okay.
But it takes about...
Fastest?
Easily, when you file an application, the courts are quite fast at coming back. But the hearing for that particular matter is not fixed immediately. I'll tell you the process straight away. I file a writ of summons. Okay? I then have to give it to the other party. I have to serve it on the other party, the tenant in this circumstance.
That means to invite them to move out?
If I'm issuing a writ of summons, I'm no longer inviting them. I'm really telling them...
That you have to move out
You have
by
to move
law.
out.
Okay.
I'm applying for that. And then he has to see whether he's got a defense. If he doesn't, then I enter judgment. It takes time. Judgment takes, if he doesn't do anything within 8 days, great. But if he responds, he has up to 22 days to go and say what he wants to say. So that takes up almost a month already, right? After that, I'll have the courts telling me, let's mediate this.
Oh my goodness, okay.
That's going to take, and that really depends on the court's calendar. Maybe a month, sometimes 2 months. By which time I'm already there 3 or 4 months and I'm just sitting there. If I wanted really, really fast in all of this, I just have to cut down on the time. That means if my clients instructed me, do it now. Or 2 days later, I must do it. But it becomes expensive, right? Because I've increased the particular time. Is it worthwhile to do all of this? It becomes, you're caught in that little space where, do I spend the money on the lawyer or do I just wait for the time and process?
Sure.
I've seen circumstances where, we've negotiated.
Okay, but what if the tenant just refused to move out even after 6 months, and you definitely have to do something?
You have to do something about it.
So when the final judgment comes, what
It could
happens?
be anywhere between 4 months to 6 months.
Would the police be involved, like to escort the tenant out? Or?
No, I mean, basically you have, when you do a writ of possession, you are getting the court's bailiff to be involved.
Okay.
He will be escorted out.
Right.
But
very rare.
very rare.
I mean, it's super
No,
rare.
I think this situation is just to test to see whether I have a solution for you. I'm very pragmatic in these circumstances, right? Because between landlords and tenants, right, the agreements are never involved with lawyers. The agreements are involved with agents. And everybody wants to just get out of the circumstance. Biggest problem, which I think is a question that you're probably going to ask me, is what's the one big issue we always face?
Yeah.
Reinstatement. It always works with, typical example, this table is nice, and then there's a chip on the table. And the guy says, there's a chip on the table, I want the table replaced. The chip on the table, it could have happened anyhow.
Right.
And so what's going to happen? You're going to tell me, the chip on the table means that I now cannot use, and therefore, when I gave you the table, it was brand new. It can't be that way, right? Because you have to give allowance for wear and tear.
Yeah.
I must expect that this particular table is not going to be lasting and looking the same 2 years ago before you gave it to me.
Right.
The biggest issues are always sofas. When you give them the sofa, it looks all nice and maybe grey or yellow. And when it comes back to you, it's all cracked, and you're going like, what happened to this sofa?
Right.
What do? Do you tell the tenant, look, you have to replace the tenant, or is this wear and tear?
Yeah.
It really depends. If there are cuts and dirt and stuff like that,
yeah.
Come on, you're obviously going to tell. Another problem that always happens, plain white walls given to you, you paint over, but suddenly the wall will look a little dent. This really upsets all landlords. They suddenly come to you and they tell you, my wall was this way and now it's been removed. There are holes in there. I'm really upset. I really want to be able to, and I have to go and find my own tenant. And of course, the last one is cleanliness. The place is always about, I gave the place, it was so nice and clean, it's dirty now.
Yeah.
I have to go and hire a domestic person to come and clean the place, it will cost $400, $500. Imagine your deposit is $2,000.
Yeah.
I do the wall, I change the furniture, and I get the person to clean the place. Meola.
Yeah, and I think these are all very important things. And I think sometimes it can be solved by doing very proper handover right at the start, taking tons of photographs, videos.
Yes.
Yeah, and I think
absolutely
giving each party the copies.
And that's exactly what my advice would be to anyone.
Yeah.
Forget just the lawyers telling you that if you want to make sure you and I'm the landlord or the tenant, please ensure that you have all of this documented.
Yeah,
because
and
most
both parties
people,
have it.
Yes.
It's in writing.
Yes, and it's signed off. And don't leave this paperwork just because, there's something for me to earn later. So therefore, it's okay, somebody else will do it. No.
Yeah.
Make sure you take the picture.
Yeah.
Okay, I'm not asking you to go and have a setup that will be able to have a production.
Yeah.
No.
Yeah.
I'm just basically telling you take the picture and record what this is.
Yeah.
Typical circumstance. There's probably a scratch on the floor.
Yeah.
Record the scratch on the floor and say it's a scratch on the floor.
Yeah.
Don't just take the picture and wait there because it makes no sense. Put a date.
Yeah.
This happened. This is a scratch recorded on this particular inspection.
Yeah, in the living room, part of this wall.
Last thing you do is, before you finish any handing over, make sure you have a joint inspection. A joint inspection, okay?
Right.
I'm not talking about you deciding to walk around yourself. Have the landlord there or landlord's agent over there. Ensure that you have this taken care.
Actually, a very good common practice we always do is that at the start of the tenancy, if the landlord is agreeable to do a full professional cleaning with receipt, with proof of receipt and stuff, then indicate in the tenancy agreement that the tenant has to do likewise at the tail end of the tenancy. So, so to reciprocate
So
that.
I'll share that with you, right? It's
Right.
the same thing with aircon. Right? The air conditioner is one requirement that you need to make sure, and probably also you have to dry clean the curtains.
Right.
Okay? Now, if I'm the tenant and I have no experience with all of this, I'll get anyone to come and do the aircon. But the landlord who has fixed such an expensive aircon or has done one is very passionate about this aircon. I may be able to have an aircon that is there 8 years, but because of my servicing, this aircon continues to remain there.
Right.
Okay, one of the biggest problems is, while I can tell you I can service it, always the issue comes back telling me, this aircon was not serviced, I have to go and service this extra, I'm going to take it out from your deposit. Same thing for cleaning, dry cleaning the curtains. So if it's not to your standard, so then if the landlord requires this to be done, he must be satisfied that it's either done by his agent or his service provider. That way he can't complain, right? He'll say, look, you want to do the servicing, you pay the service person directly, service provider, but it's my guy.
Yeah, and indicate in the contract.
Early.
Yeah, I think that's so important. We'll come to the last question, Anil.
Okay, that was fun.
So the last question is about terrible neighbours.
Okay, wow.
Yeah, and okay, so the first perspective is, as a tenant, what can I do if I experience a terrible neighbour after living there for 2 months? Then I realize I have a terrible neighbour.
Yeah.
Second part of this question is, if I'm a landlord, after 2 months of renting to my tenant suddenly call me and say that he wants to terminate the lease. They say that, oh, I didn't realize that there's a construction nearby. There's a new development coming out. It's too noisy. I want to terminate.
Let me take the second question first.
Okay, great.
Second question is a lot easier. If I have
if you're a landlord,
if I'm a landlord and I have a tenant coming to me telling me he wants to quit, right? I will tell him no way. Okay? Because quite clearly his contract is a fixed term contract. I should have addressed this very early, but tenancy agreements tend to be fixed term contracts. They tend to be for a year, 2 years. And what does that really mean? Really, it means you have to fulfill the obligation. As long as I give you exclusive possession, you pay me the rental, and everything else is functional, and you do not breach the contract. There are many terms and conditions. So even if I have someone coming and telling me, I have a noisy neighbor, I have construction around, the place is haunted, I've heard that one. A funnier one is, I cannot live here because I do not feel safe. All of these are excuses for the circumstance, because when you took over the premises, you had already done your own due diligence. There is no way you're going to tell me I'm going to be able to get out of the
assume
contract.
to have full knowledge of the place.
Absolutely.
Right.
The only circumstance in which I can get out of that, right, and we haven't spoken about it, but I think it's very important since we're talking about residential contracts, is the issue of a diplomatic clause. Now, what's a diplomatic clause? A diplomatic clause is a person It's a clause that is indicated in the tenancy agreement. It's usually applicable for someone who works overseas and who doesn't have a tendency to be a Singaporean. He's likely to be a foreigner, and he's called back to his country or his company wants to terminate his contract. Very popular with the Japanese, Koreans.
Diplomatic clause.
Yeah,
Right.
diplomatic clause, right?
But if it's like, because after 2 months, the tenant realized that there's noise and construction,
Yes, so if
no
it's
way to
not,
terminate.
yes, I'm afraid the law is the law. The contractual agreement is my binding agreement for this circumstance. It is what you've entered into.
Right.
Okay. But can you then negotiate? Now, let's just flip this, right? Can you put in a clause in there that says, look, there are certain circumstances, but there are exceptions to the rule, where you would indicate in there to say that either party can terminate this agreement with 3 months' notice. Most tenants, or rather, let me just say, most landlords do not know that they can actually do fixed-term contracts because this is provided by the agents mostly.
Yeah.
Right? The contract's already done up, already vetted by.
And a contract is a contract.
Yes.
A fixed term is a
But
fixed term.
I could actually, if I had a very clever tenant and he came to a less clever landlord, right, I could actually negotiate to say, oh, after 6 months I give you notice, I'm able to go. Then I'm afraid that's what you're bound by.
Yeah.
Okay? So, second part of the question is very straightforward.
First part, terrible neighbours.
Terrible neighbours. Okay. I written an article somewhere earlier about terrible neighbours, and the syndrome was terrible neighbour, call police. Okay. Is that the solution?
Right.
Is that really a solution for terrible neighbour, call police? And when you think about it, it shouldn't be. There was some flack for this because effectively your neighbours could be really people who had some difficulties, mental issues, and they were in the house and they were causing problems. And if I'm the tenant, what are my rights? Biggest complaint always is about noise pollution. Then there are other circumstances where the person has done certain physical acts. Okay, of course, in terms of mechanisms, we have the POHA, which is the Protection Against Harassment Act, where you feel that you are the repeated circumstances, at least more than 2 situations, incidences, have forced you to sit down and file a complaint. Okay, that's the legal aspect of it.
Right.
There's also the community justice. It's a court process, basically. It's a mediation that allows parties to go and...
But should the tenant initiate that, or should the tenant get the help from the landlord?
Effectively, you will have a landlord that says, I'm sorry, I'm not going to get involved. It's your issue directly. Remember the exclusive possession? That's exactly why.
Because you have now exclusive possession, you're responsible of your...
Yes.
So the tenant has to initiate all this,
yes, to
unfortunately.
Yes. It's the tenant's rights to be able to do so and protect himself from noise and stuff like that.
Right.
Mostly when you have these kind of problems with noise, you of course complain. From the HDB perspective, it's easier. I can go to the town council, complain to them. They will then look into mediating. But from a private property, what do you do? Of course, the first thing you do is you complain to the MCST. The MCST's general manager or facility manager will then go and talk and investigate. And then after that, he'll tell you, we've done everything. What do you do then? The noise is so noisy that you cannot tolerate. You can't sleep. What do? So obviously, you come, you get the lawyers to write the letter to complain, to tell them you should stop. Now, when it comes to such circumstances, evidence is very important. The courts are always persuaded by evidence. Record the noise.
Right.
Now, very strangely, recently a client friend had asked for advice on this matter. And this is what had happened. Now, there are only 3 people in his house, a child and husband and wife. Okay? And a mother that is probably very silent because she's got dementia. There's nobody else in the house. The unit below was very upset because he kept accusing them over a period of time that there was too much of noise. They even hired a sound specialist to go and do the recording to provide the evidence. The matter is actually now...
the neighbour doesn't has complaint about the neighbour upstairs.
Right. They go to bed at 9:30 in the morning, in the evening. 9:30, 10 o'clock, they're in bed because the child sleeps early. Okay? For the life out of him, he knows that he has actually never...
Stomp his feet on anything.
To that extent, yeah. It's not only about stomping, it's about created that kind of noise, right? But there are funny noises. Yes, he's been accused of it.
Right.
So now he's actually in court for a mediation matter.
Okay.
Now, simple reason why I'm not engaged is I told you, right? If it was more expensive to engage the lawyer to go and do this, I think it's easier if you can manage the court system to do it yourself. Like many of my legal brothers will tell me, Anil, you're supposed to be promoting our legal fraternity. No, but I mean, let's focus on the more serious work.
Right.
The more serious aspect of it is, seriously, someone has gone on to take this issue to court already. He's filed it under POHA to say that you breached your duty to me, but you've harassed me by noise, and I therefore am entitled to it now.
Right.
And I'm therefore going to make this complaint to you. I don't know what is going to happen out of it, but I'll imagine what a reasonable judge will do. A reasonable judge will say, we'll monitor this to see exactly how long, whether this goes on.
Right.
Ask MCST whether there's any noises that they've heard from other premises, because this client of mine, a friend as well, says that he also has the same problem because, suddenly in the middle of night, there's a lot of piping. I think it could be...
Sometimes it could be the internal wall issue. And
yes,
stuff.
but it sounds like as though someone is roaring away.
Right.
Or thudding sound, or thud sounds, that come about. Or thundering thud sounds that suddenly goes boop, 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 at one go.
Right. Thing is still going on.
This is still going on.
Okay.
And of course, if I was acting for him at the moment, and he's considering this very carefully, because now the matter has become, after one round of mediation, they're coming back for another round of mediation. It's going to become serious. You know how it happens in a POHA matter? How it happens is that after a POHA, I actually have to write an affidavit. I actually have to complain. I have to set the complaint up. I have to give you evidence. Now, the court is not going to accept just because your document is there. It also has to accept my reply. It has to come to me and ask me, hey, what is your response to each of them? Right. Therefore, you have to go and write your story, make sure that it's affirmation of an affidavit shows that what you're saying is true, because that's very critical. Right. And then when you put all of this together, you now have to go in, as a judge sitting over there, you have to now decide, okay, which version do I accept? I have another noise situation. It went all the way to the Strata Title Board. It went all the way there, as the STB.
Right.
Here, basically, they sit like a tribunal, listening to this situation of a complaint that was made. Okay, the matter goes up also about noise.
Okay.
In that particular matter, the STB said the noises are not justified because that particular person, after all the noise was created, disappeared. What he was doing, the noise creator who was probably up there, and this one I was acting for the person below, he was carrying dumbbells. And he was carrying his dumbbells at a certain time.
It's just dropping it down on the floor.
No one knows exactly what, but the thud sounds are, when you're carrying your weights and you finish a heavy weight and you go boom, or you're dragging, all of this noise became extended.
Right.
It became so extended that it sounded like as though the noises were just so booming into everyone's ears. So that's why the clients complained. And they were light sleepers. And they were aged. They were senior citizens who were enjoying their premises.
Right. So they put out a case through you on against.
I mean, it went through POA, and then it got it moved to the STB.
Right.
At some point of time, it didn't make sense for them to continue. They decided just to leave it as it is.
Right. But this is a lengthy process, I presume.
It is a lengthy process.
Right.
And unfortunately, we don't have a mechanism for quick justice.
Okay.
We don't.
Right. And that's where you guys come in to just find the best solution, I believe.
In this subject matter that you are dealing with today with me on landlords and tenants, is there a right answer or wrong answer to how to deal with it? Because at the end of the day, I will stop pursuing all my litigation and my legal matters if I can find my peace of mind. Then the easiest way is to let's talk about it and negotiate it and mediate it, come to a compromise and agree to comply with it. Right. It's not an easy answer. I'm afraid I don't have an easy answer. I've realized that
definitely not
there are going to be 50,
well.
100 people on maybe even your own chat to tell you that no way, there's no possibility. I'm an optimist. I always feel that there's a way to negotiate matters because at the end of the day, there's a cost unless you do it yourself.
Right.
And there's also still time.
Yeah. Opportunity cost in terms of money and time.
Always.
Yeah. I like what you mentioned, as long as you have a peace of mind at the end of the day. Yeah. And I believe your job definitely isn't easy. Thanks for coming onto the show.
Thank you.
It's such a pleasure. It's an honor to have you. Yeah. And I think our listeners and audience definitely will benefit so much from today's session with Anil from DL Law Corporation. And we are so glad to have him. If you want him back on the next episode to talk about more things, do leave your comments down below. And I'll be very happy to have Mr. Anil back.
Thank you.
Thank you so much.
It was a pleasure.
Thank you. Lengthy process, I presume.
It is a lengthy process.
Right.
And unfortunately, we don't have a mechanism for quick justice.